Hey everyone, this is Ryan Bradshaw, and today we're talking about business law, chapter 9, and that has to do with employment, worker protection, and immigration law, or basically labor laws. And so we're going to go through like we have been doing and just kind of give you an overview of the chapter. Once again, this is not intended to replace the reading. This is meant to just give you a foundation to build upon as you go into the reading, as you go into the assignments. This is a supplemental video, so if you have any questions, you can always reach out, and I'm going to go ahead and jump into the first section. And so, in the United States, in many other places, we have this thing called at-will employment. And at-will employment means that you are there because of your own will. You choose to be at that job, and the place of employment employs you at their will. They choose you to work this job. What that means is that there generally is no obligation to maintain employment on either side, meaning that you can walk away at any point that you choose to, and they can terminate you or not continue your employment at any point they choose to. And so this is a good thing and a bad thing. Just like everything else in life, there's good and bad. On the good side, you are a free agent. You can go and seek out employment, seek out other opportunities wherever you so choose. However, on the downside of that, being a free agent means that you don't have any or much comfort in the fact that you are secured in your employment. There's very few jobs in this world where you have really secure employment. And so you always want to treat every day like it's an interview. Every day, if somebody is trying to, think about it in these terms. Every day you wake up, somebody is trying to outcompete you at what you do. Somebody is vying for your job. When you leave a job, somebody's there right behind you to apply and to step into that job. And so you want to treat every day like an interview. Every day you want to give good performance, make sure that you're doing what you need to do in order for people to keep you employed. And so the concept of at-will employment does, however, continue today, and all employees are considered to be at will unless they are employed under a collective bargaining agreement or a contract for a set duration. So even a contract, let's say that you have an annual contract, and for whatever reason, there is a disagreement, whatever it may be, and you decide, or they decide there's going to be a separation. Depending on the circumstances, they may or may not have to honor that contract and pay you out. So meaning that you may not work there, but they will buy out the rest of your contract in order for you to seek opportunities elsewhere. And so a collective bargaining agreement, that's basically a union, and some unions supersede the at-will status, so they may be able to protect your job more than non-union jobs. So health and safety is a big part of why we feel comfortable in our jobs. Nobody wants to work in an unsafe work environment, and OSHA, the Occupational Safety and Health Act, and it's administered by the Occupational Safety and Health Administration, OSHA, is there to ensure that employers are doing exactly what they're supposed to do in order to meet the guidelines for safe working conditions. There's some other things that fall into consideration. The Workers' Compensation Act. If you are injured on the job, are you going to be compensated for that because you were doing your duty on the job, and depending on the circumstances, it may or may not be your fault that an injury occurred because of your regular work performance. And so there's a couple cases it talks about, Kelly versus Ryan, and of the Workers' Compensation, Ohio Bureau, Coca-Cola, and Coca-Cola was involved in that. So read that case law. So the Fair Labor and Standards Act deals with provisions or categories of child labor, minimum wage, and overtime pay. Yeah, child labor is not something that you hear about a lot these days in the United States. It does occur in other places around the world. But generally in the United States, we used to have it where young children, small kids, go work in factories for a wage, and they were injured, often because kids see things, they like to grab things, touch things, mess with things, and they don't really think about safety. And so we have laws that govern when kids, step into roles within, a work environment. And so minimum wage actually is there to make sure that you're being paid at least a certain minimum threshold. It's been a while since minimum wage went up, so maybe we can get some improvements on that in the coming short term. And then overtime pay, yeah, if you work over 40 hours, you should be entitled to at least what's time and a half of your hourly rate. So if you make $10 an hour, overtime pay would be 15. And there's also the Family Medical Leave Act, which is a protection in place that deals with things like birth of a child, adoption of a child, placement of a foster child in the employee's care, the care of a seriously ill spouse, parent, or child, or any serious health condition that prevents the worker from being able to perform any of the essential functions of the job. So FMLA is there to protect your job for 12 weeks in case that you do have an illness in your family that falls under the protections of this act. And I don't think it's a blanket coverage, but I don't think the flu might be an appropriate use case, depending though. But if you have a serious illness, definitely would be a use case. These things have to go through proper protocols, and so each case has to be determined on the merits of that case. And so just know that there is a process that you go through in order to apply for FMLA protections, but you can do that through your employer's HR office. And so ending employment, there are also several regulations that cover workers who are terminated or lose their employment, summarized in the following table. COBRA, if you lose your job, you lose your health care in a lot of cases. This is meant to build a bridge between the last health care you had at your one job and the next health care you get at your subsequent job. So let's say, lose your job, whatever reason under the sun, and you've got a 2-3 month gap before you get a new job. What are you going to do? No insurance for 2 or 3 months? So COBRA is a way to mitigate that or minimize the potential negative outcomes. So Employee Retirement Income Security Act deals with basically compensation for retirement protections and things like that. And then the unemployment compensation. You've heard about if you are unemployed, you can file for unemployment and get that. So, and then immigration laws are also part of that. So be sure to read about that information. Labor law. Jump to this next thing. And so labor relations is the general term used to describe the relationship between employers and employees, as well as the governance of that relationship. It refers to the micro-level interactions that take place between workers and individual managers, as well as the macro-level relations that occur between the external institution that are tasked with governing such relations. So trade unions. What is a trade union? Trade union or labor union is an organized group of workers who come together to lobby employers about the conditions affecting their work. The idea behind a union is separately we cannot accomplish a lot, but together we can accomplish more. And I have very mixed feelings about unions. I guess my opinion doesn't matter. It's what your opinion is. But I've seen kind of both sides of the coin. I'll just give you the story briefly. When I got out of college, I didn't learn a lot about unions in college. And unions are really not as prevalent as they used to be. But didn't learn a lot about it. But when I got to the job, I had several trainings about unions. And I worked at Walmart, and I was in the management team. And saying the word union or talking about anything union was very taboo. They didn't want you to really mention or talking about it. And it was so taboo that if you did hear talk of a union, you had to report it. And that could be considered an actionable item, meaning that if they deemed the information was threatening, that a union would form and collective bargaining could occur, Walmart corporate would send out a union team to address the severity of the situation and basically, for lack of a better way to explain it, union busting. If there was going to be a union, they would make sure it didn't happen under whatever circumstances. They would, without any circumstances, they would actually close the store down in order to avoid a union forming. Why do you think that is? Because when a union forms, it gives the union collective bargaining rights. And so collective bargaining means higher wages often, it means better benefits, and stores and organizations don't want to pay more money. And so that's why they're so anti-union. I see both sides of it. I really, from an entrepreneur side, yeah, I can see how unions interfere with business. From a worker side, I can see how unions defend workers' rights. So I do see both sides of it. I'll tell you a good follow-up if you're interested in the topic. There's a documentary on Netflix called American Factory, and it talks about labor in the United States. It talks about American factory workers, and it talks about unions. So check that documentary out, American Factory. And so development of labor laws. 1886, the American Federation of Labor was formed. 1932, the Norris-LaGuardia Act was passed. This act prohibited yellow dog contracts, or contracts that prevented workers from joining labor unions, meaning that if you work here, you have signed a contract saying that you will not join a union. That's what that law prevented. 1935, Congress of the Industrial Organization was established. This establishment extended the union movement because it allowed semi-skilled and unskilled labor workers to become members. 1935 also, the National Labor Relations Act was passed, also called the Wagner Act. This act is a major statute in the United States labor law. The act established that employees have the right to form, assist, and join labor unions, to engage in collective bargaining with employers, and to engage in concerted activity to promote those rights. So you do have a right to join a labor union if so inclined. 1947, the Labor Management Relations Act, also known as the Taft-Hartley Act, imposed restrictions on power of labor unions, made the changes to union election rules, and outlined the provided remedies for 6 unfair practices by labor unions. And they're listed below. Labor Management, and this is 1959, the Labor Management Reporting and Disclosure Act, or the Landrum-Griffin Act, was passed, which regulated the internal affairs of trade unions, as well as their official relationship with employers. And then lastly, 1988, the Worker Adjustment and Restraining Notification, or the Warren Act, requires that employers with more than 100 employees give workers at least 60 days before engaging in layoffs or plant closings. And the Taft-Hartley Act, things that it actually made happen, it protects employees from unfair coercion. I'm not going to read them all for time purposes, but please go through and read these and review that information. So National Labor Relations Board, it's basically the NLRB was established to administer, interpret, and enforce the terms of the National Labor Relations Acts. It has jurisdiction over all workers except for the government employees and employees in the transportation industry who are governed under a separate statute, the Railway Labor Union. The Railway Labor Act. Other workers are not covered by the NLRB include agricultural workers, confidential employees, independent contractors, and those employees employed by a spouse or a parent. It has 3 main functions: to monitor and conduct the conduct of unions and employers, to remedy and prevent unfair labor practices, and to establish rules interpreting the NLRA. So good stuff. And so organizing a union, you really have to get together and determine if you want to form a union within the group of individuals. And there is a election that happens, and then if a union is implemented, then you can go into collective bargaining, which is where you put forth terms that you want. If they do not honor those terms, there is a strike that can occur. And you've heard about strikes in the past where they walk out. So strikes are one method, boycotts are another. And then lastly, equal opportunity in employment and the Civil Rights Act. I want you to go read about both those to wrap up the chapter. Really, really good stuff. I appreciate your attention, and if you have any questions, please reach out to me. I'm happy to talk. Have a great rest of your week, okay, everybody? Talk soon.